During this difficult time, I want to offer my deepest sympathies to the families of the Americans who were attacked and kidnapped. Today, the Department of Justice filed a civil antitrust lawsuit in the U.S. District Court for the District of Massachusetts to stop the merger of JetBlue and Spirit Airlines. We are joined in that lawsuit by the Commonwealth of Massachusetts, the State of New York, and the District of Columbia. I'm here with Associate Attorney General Vanita Gupta and Principal Deputy Assistant Attorney General Doha Mekki. Our complaint alleges that JetBlue's proposed $3.8 billion acquisition of Spirit violates Section 7 of the Clayton Act. We allege that if allowed to proceed, this merger will limit choices and drive up ticket prices for passengers across the country. And we further allege that the impact of this merger will be particularly harmful for travelers who rely on what are known as ultra-low-cost carriers in order to fly. Those include working and middle-class Americans who travel for personal as opposed to business reasons and who must pay their own way. By acquiring Spirit, JetBlue will eliminate the largest ultra-low-cost carrier in the United States. Today, JetBlue and Spirit compete on hundreds of routes that serve tens of millions of air travelers every year. Direct competition between the two airlines has intensified in the last 5 years as Spirit has expanded into markets where JetBlue already offered service. On dozens of routes serving tens of millions of passengers, JetBlue and Spirit have large combined market shares. For example, on the Boston-Miami-Fort Lauderdale route, which serves about 1.5 million passengers annually, JetBlue and Spirit together currently account for nearly 50% of the market. For service between Boston and San Juan, the two airlines account for nearly 90% of the passengers flying the route today. And on some routes, JetBlue and Spirit are the only two carriers providing nonstop service, such as between Miami-Fort Lauderdale and Aguadilla, Puerto Rico. Eliminating the competition between JetBlue and Spirit on these and other routes would eliminate Spirit's unique and disruptive role in the industry and significantly harm consumers. As noted in the complaint, Spirit's own internal documents estimate that when it starts flying a route, average fares fall by 17%. And an internal JetBlue document estimates that when Spirit stops flying a route, average fares go up by 30%. As outlined in the complaint, if the acquisition is approved, JetBlue plans to abandon Spirit's business model, remove seats from Spirit's planes, and charge Spirit's customers higher prices. Spirit executives have recognized the harmful effect the proposed merger would have on consumers. After JetBlue offered to acquire Spirit, Spirit's board of directors warned its shareholders that JetBlue's plans to reconfigure Spirit's planes would, quote, significantly diminish capacity and result in higher prices for consumers. Accordingly, the board of directors further warned, quote, a court will be very concerned that a JetBlue-Spirit combination will result in a higher cost, higher fare airline that would eliminate a lower cost, lower fare airline and remove about half of the ultra-low-cost capacity in the United States. We agree. This proposed merger occurs against the backdrop of an already concentrated airline industry. 4 airlines, American, Delta, United, and Southwest, control close to 80% of the market. We allege that JetBlue's proposed takeover of Spirit will only exacerbate concentration and further stifle competition in the airline industry. JetBlue's elimination of Spirit as an independent company increases the risk that the remaining airlines, including JetBlue, would coordinate to raise prices or reduce capacity on particular routes where Spirit currently operates. In short, if not blocked, the merger of JetBlue and Spirit would result in higher fares and fewer choices for tens of millions of travelers across the country. The Justice Department is suing to prevent that from happening. I want to thank the attorneys and staff of the Antitrust Division for their excellent work on this case. And I want to reiterate that the Department continues to closely examine practices and review proposed mergers to ensure that they are consistent with federal antitrust law. Companies in every industry should understand by now that this Justice Department will not hesitate to enforce antitrust laws and protect American consumers. I will now turn the podium over to Associate Attorney General Gupta.
Thank you. Like the Attorney General, I want to thank the leadership and staff of the Antitrust Division for their incredible work on this matter. I want to especially acknowledge Principal Deputy Assistant Attorney General Doha Meki, from whom you'll hear shortly, for her incredible leadership in promoting competition. Our complaint alleges that JetBlue's acquisition of Spirit would particularly hurt those travelers who can least afford to see travel costs rise. Ultra-low-cost carriers like Spirit play a key role in the economy. They make air travel possible so more Americans can take a hard-earned family vacation or celebrate and mourn together with loved ones. We allege that the proposed merger would lead to fewer seats and higher prices for travelers. And we allege that the proposed merger would heighten the risk that remaining airlines would coordinate to raise prices. As Spirit's own presentation put the point, a JetBlue acquisition of Spirit will have lasting negative impacts on consumers. And many of the consumers it hurts will be the most cost-conscious travelers. Our complaint rests on well-established theories of anti-competitive harm. It is also an example of an enforcement action that promotes access to goods and services for all Americans, including those who are most likely to need ultra-low-cost carriers to fly. As a senior Spirit official told Congress in 2020, Spirit's product is designed for highly price-sensitive travelers, like ordinary individual consumers and families who are an underserved segment in today's market. And this case is not unusual. Threats to competition like those alleged here are particularly likely to harm working and middle-class families who may struggle to withstand the price increases that consolidation often brings. The Department's commitment to ensuring economic opportunity and fairness means holding those concerns in the front of our minds. Keeping the economy open to all Americans, regardless of income status, is a priority across the Department. That effort includes the Civil Division taking on nursing homes to defraud vulnerable seniors, the Tax Division shutting down tax preparers who exploit workers and families, and the Antitrust Division going to court to fight companies that fix their workers' wages. It includes working to improve the bankruptcy process to provide a fresh start to deserving debtors. In recent months, the Civil Division has put out guidance to ensure that student loans are properly treated in bankruptcy, and the U.S. Trustee Program has launched a pilot program so that debtors no longer need to take a day off work to attend a meeting of creditors. And it includes redoubling our environmental justice efforts to ensure that all Americans, regardless of income, background, or place of residence, be it Jackson, Mississippi, LaPlace, Louisiana, or elsewhere, have clean air, safe drinking water, and a healthy environment. This work is more than the sum of its parts. Together, our efforts represent the Department's commitment to ensuring that our government and our economy work for everyone. I'll now turn it over to Doha Meki, who will speak more about the details of our complaint.
Good morning. Thank you, Attorney General Garland and Associate Attorney General Gupta. This morning, we filed a lawsuit to block JetBlue's proposed acquisition of Spirit. Spirit is a disruptive, low-cost airline. It is also the largest and the fastest-growing ultra-low-cost carrier in the United States. As we alleged in the complaint, JetBlue itself has recognized that, quote, competition from Spirit lowers its fares more than competition from other low-cost carriers. Indeed, under federal antitrust law, the transaction is presumptively illegal on more than 150 routes and markets where JetBlue and Spirit fly today. For years, Spirit's business strategy, a unique business strategy, has earned it a reputation for being a disruptor, a maverick, in a commercial airline industry beset by high concentration and oligopolistic practices. Customers throughout the United States benefit from an independent Spirit. Simply put, where Spirit competes, other airlines, including JetBlue, respond by competing vigorously and lowering the price of airfare to attract customers. After spending many years criticizing consolidation in the airline industry, JetBlue appears to have changed its tune. JetBlue has previously warned that, quote, all that power in the hands of a few very deep-pocketed airlines has implications for consumers in the form of reduced options, high fares, and often poor service. Rather than compete to win share, JetBlue has chosen to consolidate and cooperate instead of compete. In 2020, JetBlue committed to what Spirit previously described as a, quote, de facto merger with American Airlines, which you may know is the country's biggest commercial airline. Today, JetBlue has already devoted 75% of its capacity to American Airlines, which we believe comes at a harm to passengers. But JetBlue wasn't done. JetBlue engaged in a public courtship of Spirit, which was rejected more than once until Spirit finally accepted its offer. We agree with JetBlue's diagnosis, but not with its proposed cure. The best way to address consolidation is not more consolidation, it is competition. As we allege in the complaint, flyers of all types benefit from competition that both JetBlue and Spirit offer. JetBlue often touts its, quote, JetBlue effect, but it also has recognized that its own fares and revenues drop significantly when Spirit enters the market. This means that the Spirit effect happens on routes that JetBlue already serves, so that whatever benefit JetBlue entry and the JetBlue effect offer, there are additional Spirit effects when Spirit enters. We filed this lawsuit because the federal antitrust laws protect this competition between JetBlue and Spirit, and because travelers should not have to make false choices between the two airlines. The complaint details the many ways this acquisition threatens competition. Some of those ways are obvious. Travelers will no longer benefit from the head-to-head competition between Spirit and JetBlue that drives down airfares. In an airline industry beset by high concentration, travelers will no longer benefit from the fact that Spirit has no obligation to follow the herd when it comes to the airline industry's too frequent efforts to coordinate their price increases. Travelers who are looking for the lowest fare and more control over how they spend their money will no longer have a chance to choose Spirit's low-priced, unbundled fares. There are also some less obvious ways that this acquisition threatens competition, and they are no less important. The low-priced basic economy options that nearly all airlines offer today did not happen by accident. They came from disruptive choices that Spirit made that the other airlines had to respond to. That innovation and the chance for others that Spirit would bring to the market in the future will be lost unless this acquisition is blocked. JetBlue's acquisition also stops competition that we can't see today. Spirit has grown significantly and had planned to continue doing so. Spirit is already 6 times larger today than it was in 2010. Even while the pandemic went on, Spirit stayed focused on its growth plans. It planned to double its fleet of airplanes by the end of 2025. Absent this acquisition, Spirit had expected to add flights to 5 new cities just this year, and it expected to offer more flights from 4 important JetBlue-focused cities. All that growth would have meant more competition for JetBlue and other airlines, and if this acquisition is completed, all that growth will be over before it even has a chance to start. Travelers know, now and in the future, they will be better off if JetBlue and Spirit remain independent competitors. In closing, I want to thank the tremendous team of lawyers, economists, paralegals, and professional staff at the Antitrust Division who investigated this merger and filed today's lawsuit. They are exceptional public servants, and I'm so proud of them. We owe them a debt of gratitude. I also want to thank and acknowledge our co-plaintiffs and our law enforcement partners, the Commonwealth of Massachusetts, the State of New York, and the District of Columbia, who are once again working alongside us to ensure that consumers in those jurisdictions and around the country benefit from vibrant free markets. Finally, I want to thank our colleagues at the U.S. Department of Transportation. As in prior matters, we have worked closely with them throughout our investigation to determine how to use our respective enforcement authorities to best protect competition and consumers.
Wall Street Journal. How does the government respond to the JetBlue CEO's claim that your mind was made up from the start to block this deal? And then separately, Doha talked about the American JetBlue arrangement. Does that agreement at all contribute to your finding that this particular merger is illegal?
So on the first question, I've read the reports this morning of the arguments that the parties are making. We'll be answering those in our pleadings. And on the second question, the complaint sets out that this merger will exacerbate the problems caused by that alliance, but that even without that alliance, it violates the Clayton Act.
Mr. Attorney General, can you confirm the information released by the Mexican government this morning that the 4 Americans have been recovered, but that 2 of them are dead? And what does this incident say about the extent to which the cartels are operating with impunity in some parts of Mexico?
So on the first part, I can't say anything more than I've already said. When we have more definitive information, we will announce it publicly. And on the general problem of the cartels, look, the cartels are responsible for the deaths of Americans. And we are fighting as hard as possible. The DEA and the FBI are doing everything possible to dismantle and disrupt and ultimately prosecute the leaders of the cartels and the entire networks that they depend on.
Attorney General, given the problems that the department identified with the earlier JetBlue American alliance, is there any thought about doing something about that? Is there any recourse for the department to revisit some of that alliance and that agreement? And then, if I can ask an off-topic question, yeah, sure, absolutely.
If I understand correctly, that matter is in court right now. We've made our arguments against that alliance, which we regard as a de facto merger, and we are awaiting the results of the court's decision.
The January 6th investigation is the largest in the history of the department. On television last night, one program aired some video and characterized it as sightseeing by a bunch of people coming into the Capitol who revered it. You've seen some of that video. What's your reaction to that?
So I don't want to comment on any particular reports. I think all Americans saw what happened on January 6th, and most of us saw it as it was happening. It was a violent attack on a fundamental tenet of American democracy, that power is peacefully transferred from one administration to another. Over 100 officers were assaulted on that day. 5 officers died. We have charged more than 1,000 people with their crimes on that day, and more than 500 have already been convicted. I think it's very clear what happened on January 6th.
Hi, Leon Island with Bloomberg. A lot of the complaint focuses on concerns about Florida. The Florida Attorney General took a settlement after the airlines said that they would expand service down in Florida. I wonder if you could talk about why any proposals from the companies were not sufficient to address your concerns.
So in general, about Florida and any other state, they have different laws than the United States does, and they have different interests than the United States does. Our job is to enforce the Clayton Act, and I think as set forth in the complaint, it's very clear why this is a violation of the Clayton Act. On the divestiture proposals, I'm going to let Doha speak about it a little bit more, but these proposals have only speculative consequences, as we set forth in the complaint. The barriers to entry to a new entrant in any of the markets are extremely high with respect to gates and landing rights and availability of pilots and planes. So we think the divestitures are speculative, but I'll let Doha answer more specifically.
Thank you, Attorney General Garland. I think all of that is exactly right. I would only add that it is the longstanding policy of the Antitrust Division that when a divestiture is offered to address an otherwise illegal merger, that the divestiture has to fully replicate the competition that would be lost as a result of the merger, which also means replicating the competitive intensity that would be lost as a result of the merger. In airline cases, divestitures of routes don't actually happen. Airlines can divest landing slots and landing rights and gates. And so even if a hypothetical set of merging parties offered to divest a certain gate, there's no guarantee that the divestiture buyer would fly the same route. In other words, they might fly somewhere else.
Great. Thank you, everyone.
Thank you.